employer liability for unlawful harassment. The company's always going to be liable for harassment by an owner or supervisor if it culminates in a tangible employment action. So if you have a supervisor who's committing harassment, they're making comments, something along those lines, you know, let's go out tonight, let's go out and have a beer, you look great, and that ends up culminating in a demotion, a termination, or transfer, then under those circumstances, the company's going to be liable unless they can show an affirmative defense, which we'll discuss here in a minute. Standard liability is based on the principle that the company is responsible for its owners and supervisors. The employee's position is unharmed. So, you know, just backing up, if I could actually back this up, which I can't, if it's harmed, then you're going to be on the hook. There's going to be vicarious liability. The company's going to have to pay and defend the supervisor. If the employee's position is unharmed, it's up to the company to prove an affirmative defense, and the affirmative defense would include that you have a policy in place. We'll talk a little more about that shortly, and that you've enforced that policy. To lessen the severity of the company's liability, you've got to show that you as a company exercise reasonable care to prevent and correct promptly any sexually harassing behavior, and that the employee unreasonably failed to take advantage of the opportunities presented. So, with respect to number one, how did you exercise that reasonable care? Do you have a policy in place? Is that policy actually communicated to employees, or is it just in some dusty handbook that you gave to employees when they signed up with you? You've got to have policies in place that are legally compliant, and you have to enforce those policies. You need to train your employees. You need to go over these things. It shouldn't just be, welcome to your first day of work, here's the employee handbook. Take a look at this, let us know if you have any questions, and then it's never discussed again. And with respect to the second element there, to lessen a company's liability, talking about the employee unreasonably failed to take advantage of preventative opportunities. So this is one of the ways that you as a company can protect yourself. You have a policy in place. The policy says, well, if harassment occurs, you need to go to HR. And if you're uncomfortable going to HR, then you go to the owner. You should have several avenues for employees to report their concerns. If that employee never mentions that to anyone and simply goes and files a charge of discrimination, your defense as an employer is that, well, wait a minute, we didn't know anything about this. We're not psychic. So until someone tells us about this, we really can't do anything about it.